And good evening. I'm Trevor Morrison. I'm the dean of this law school, and I'm really thrilled to welcome all of you to the 20th Derek Bell Lecture on Race in American Society. It is an honor to participate in this fantastic tradition. This is my third lecture, and it's already become something I look forward to starting tomorrow for the next one. I'm really delighted to see so many people here this evening that were part of Derek's life. Former students, colleagues, friends, and family. We're especially honored to welcome his sister, Janet Bell, his sons, Carter and Derek Bell III, and his widow, Janet Dewart Bell, and her brother, Dr. William McCoy. Where's William? I haven't seen him yet. There he is. Hello. While I did not have the privilege of knowing Derek during his life, or being a colleague of his on this faculty, I certainly can attest to the profound impact that he has had and continues to have on this law school, and indeed on the law and society more broadly. And I know that many of you can attest to that as well. It is not an overstatement to say that Derek was and is a colossal figure in constitutional law, in civil rights law, really as one of the consciences of this country. His leadership as a scholar, as a teacher, and as an activist helped to foster a dialogue on the progress or lack of progress of racial reform in the United States, a dialogue that continues today. His steadfast sense of integrity permeated every phase of his celebrated career, from his early role as the only African American among hundreds of lawyers working in the Civil Rights Division of the Justice Department, to his role at the NAACP Legal Defense Fund under Thurgood Marshall. And of course, later in his career, Derek challenged law schools across the country to embrace diversity in their hiring practices, and he held them accountable when they did not. We are so fortunate that Derek eventually chose NYU Law as his academic home, where he was admired by faculty and students alike. In 2012, Derek posthumously received one of our Distinguished Teaching Awards for his outstanding achievements as a constitutional law teacher, and that's just one of innumerable examples I could list of his well-deserved honors. And tonight, we gather to celebrate Derek's extraordinary legacy and to remember the countless lives that he touched, the debates he provoked, the causes he championed. But today is not just about looking back on Derek with respect and admiration, though of course we do that today and in all days. Today is also about carrying his legacy forward to continue to enhance and expand the important work he set forth for racial reform in the United States and around the world. Thus, the mission of this lecture series is to examine the role of race in American society. It has served as truly a critical platform for leading scholars and activists to share their work on racial justice and civil rights, and we continue that tradition tonight with our own graduate, Sherilyn Ifill, graduate of the class of 1987, now president and director counsel at the NAACP Legal Defense and Education Fund. She will continue the tradition of the Bell Lecture with her talk entitled America Divided, Brown's Predictive Power and the Urgent Moment for Racial Equality. We're really thrilled to welcome Sherilyn back to the law school. She will be introduced formally in just a moment by our Vice Dean, Randy Hertz. But first, I want to introduce Janet Bell, who has been an integral member of the law school community for so many years. Indeed, the Derek Bell Lecture Series was conceived by Janet, many of you may know this, as a gift for Derek's 65th birthday. And it's not surprising that Janet would think up such a compelling event, given her own professional and personal commitment to education and communication and social change. Her own career has again, unsurprisingly, been marked by an enduring dedication to volunteer service and to promoting initiatives that increase diversity and equal rights for all. Now, before welcoming her to the stage, a word of congratulations for her. There's been an important milestone reached because just earlier this year, Janet earned her PhD. I think I have this right. Her dissertation is titled African American Women Leaders in the Civil Rights Movement, a Narrative Inquiry, an Enduring Leadership Legacy of Authenticity, Courage, and Purpose. She literally embodies her own scholarship in this sense. We are so grateful to have Janet Dewart-Bell with us tonight. Please welcome Dr. Janet Bell.
Thank you. I travel across this country, and with Derek, I've been to many, many law schools, and the love at NYU Law School can't be beat. Don't you love this dean? Derek lived to teach, and teaching kept him alive. For him, it was always students first. It was a mantra in our household. I, too, want to say that in Derek's background, in that universal encyclopedia, his portrait is next to the definition of mentor. For him, there was no higher calling than teacher. It is always gratifying and humbling that students who never met him in person are very much his students, continuing to carry on his work with integrity and dedication. Let me acknowledge the three Bell sons, Derek Bell III, Douglas Du Bois Bell, and Carter Robeson Bell. Yes, you note the significance of those names. Our family wit, Carter, says that he has three last names. Carter being in honor of one of Derek's mentors, Judge Robert L. Carter, and his wife, Gloria. The late Judge Robert Carter argued the first Brown v. Board of Education case before the Supreme Court and taught at this law school. By the way, Derek's other mentor was the late civil rights attorney and judge, Constance Baker Motley. There are many people to thank. Thanks must go to our adopted daughter, Lisa Marie Boykin, NYU 95. Y'all can stand up, raise your hand. A first among equals who remains a faithful and incomparable standard bearer of the Bell legacy. Other adopted first among equal daughters here tonight include Lisa Jones and Linda Singer, here with her daughter and Derek's goddaughter, Erin Sternley. Please stand up, Erin. Oh, come on, do better than that. She's 18. She became Derek's goddaughter when she was 13 for her bat mitzvah. I especially want to lift up the memory of Derek's first wife, a truly phenomenal woman, Jewel Hairston Bell, who died before Derek and I met. As partners, she and Derek blazed trails together. 20 years ago, the Bell Lecture co-founders shared a dream with me, Judge Robert L. Carter, Paulette Jones Robinson, and Valerie Kavanaugh and William Kerstetter, who are here once again from California. Where are you? Bill and Valerie represent an illustrious and fierce group of social justice and legal advocates. Joining our village is the international lawyer Alice Young, one of Derek's first students at Harvard. She, along with Harvard professor and former Bell student, helped endow this series. And there were major assists recently from Dr. Kitty M. Steele and Louis Steele and from Ted and Nina Wells. The Steeles and Nina Wells join us this evening. And why are people so shy? I don't understand this. Okay. Now, Bell Lectures have been consistently wonderful. Stellar academics who also have social justice advocacy in their DNA. The tradition continues tonight with the wonderful Sherilyn Ifill. Also with us are previous Bell lecturers William Chip Carter, professor and dean at Derek's alma mater, the University of Pittsburgh, and Kendall Thomas, professor at Columbia Law School. Deep personal thanks goes to former dean and university president John Sexton, a Bell student at Harvard who championed this lecture series from the very beginning, to his successor, Ricky Revesz, and also enduring thanks to BLAPA, the Black, Latino, Asian Pacific American Alumni Association. Say that 3 times without stumbling. And to its president, Rafiq Kalamuddin. Very special thanks must go to the staff of the Office of Development and Alumni Relations for their care and attention to this lecture series year after year. With grateful acknowledgement to the shy, I hope she's in the room, Kelly Spencer, for going above and beyond the call of duty. On behalf of the Bell extended family, I again pledge our continued commitment to this wonderful law school, represented in part by this lecture series and the courtyard bench with a plaque in Derek's honor. I urge you, if you've not done it already, but if you have, do it again. Go to that bench, reflect, and renew your commitment to the law and social justice. Lastly, I love this part. I'd like to thank the brilliant, kind, and humble Vice Dean, Randy Hertz, who gets very embarrassed quickly, the faculty liaison for this lecture series since Derek's passing. Students love Randy, as do I. As with Derek, Randy is student-focused. I call him student-obsessed. He is truly a gentleman and a scholar. He will introduce tonight's lecturer after what has also become a tradition of these series. I'm calling Rosborough back to the stage for a second. Now, Derek loved music. Almost every Bell program includes music. And tonight you've heard the wonderful Rosalind Burrow, accompanied by Brian Whitted. They are world-class musicians and friends. Roz has only done 17 Broadway shows. Now, every year, some of you apparently do not get the memo that we're doing the Stevie Wonder version, so fasten your seats. Tonight is more than a lecture. It is a celebration of Derek's exemplary life of meaning and worth, and it's also his birthday. So with that, happy birthday to you. Happy birthday to you. Happy birthday, happy birthday to you. Happy birthday to you. Happy birthday, happy birthday, happy birthday, happy birthday, happy birthday, happy birthday, happy birthday to you, happy birthday to you, happy birthday.
Thank you, Dr. Bell. So one of the greatest perks of being the faculty liaison to this program is having the privilege and pleasure of being able to stand up here each year to welcome the greatest scholars in the country on the issues of race and law. It's an especially wonderful joy for me to do that this year because I knew Sherilyn when she was a student, and I've watched her incredible career develop and flourish. So, when Sherilyn was a student, it was clear she was going to great places. I remember, you won't remember, I remember being a judge on a simulated argument that you did. Oh, you remember. And I'm sitting there watching this young law student argue, and I'm thinking to myself, wow, she is a powerful oral advocate. And I thought, I don't know where she's going to end up, but she's going to do great things. And of course, you have. So after that, you went on to the fellowship at the ACLU, and then Sherilyn followed in the footsteps of the great Derek Bell by going to become an assistant counsel at the Legal Defense Fund, where she worked for 5 years as an assistant counsel, focusing on voting rights and making a name for herself as one of the best civil rights lawyers in the country. And then after that, she went on, again following in the footsteps of the great Derek Bell, and went into academia. And those of us who knew her at the time, well, actually, I knew her at the time and I tried to convince her to come here, but she wanted to go to the University of Maryland, which was a mistake, but I understand. I understand there were reasons. But she went on there to do great things in the field of race and the law, civil rights, voting rights. She wrote amazing, groundbreaking scholarship, a widely acclaimed book, and she became one of the leaders in the country of legal pedagogy, creating a clinic and also revamping the first year of the University of Maryland Law School's program so that it would integrate real-life perspectives and provide a greater and broader perspective on the law. And then after doing that for several years and being one of the best academics in the country, then she returned to the Legal Defense Fund in 2013 as the leader of the Legal Defense Fund. And it's no news to anyone who's in this room that these have been troubled years in racial relations. Of course, we've had too many decades of troubled times in racial relations. It is wonderful for the Legal Defense Fund and wonderful for our country that we have someone with Sherilyn's brilliance and creativity and steady hand at the tiller to lead the organization and all of us through these troubled times. So, Janet talked about this event as bringing together an extended family, and she mentioned a number of the Carter kids and also his students who are, of course, part of his family. I like to think that we are all spiritually and philosophically part of the Bell family. So I would like to welcome Sherilyn here as part of the Bell family, but also as part of the NYU family. And we are welcoming back one of our kids, and we're so happy to have you back. So join me, Dr. Bell.
Thank you. When my kids come home, they usually want money and food, so. So, first of all, thank you. This is in no particular order, but thank you to Dean Morrison and to the NYU faculty, to all of you who came out tonight, especially to the students. As I recall from my days living on Mercer Street, Thursday night was a kind of big party night, so I appreciate your being here. I want to thank the Bell family. This is just truly an honor. And I want to thank the lawyers and staff members from the Legal Defense Fund who came to support me tonight. Where are you? Woo! Appreciate that. Also, my best friend and former NYU Law School roommate and partner in all manner of shenanigans down in the Village back in the day, Gemma Solimene, and her husband, Pedro Morales. And my husband, Ivo Knobloch, for being here with me. I just want to say a quick word, and I don't want to be too long, but just when you talked about Derek being a mentor, I'm going to talk about Janet in a minute, but just want to say something about Derek being a mentor, because he was a mentor to me. He convinced me that I could get a fellowship at the McDowell Writing Colony to finish my book. He said, you could do it, apply, and I thought, that's crazy, there's no way they'll accept me, and I did it, and I was accepted, and did some of my best writing there, and always was a great sounding board. And what I loved about Derek is he was never congratulatory about anything I did. No, he was always pushing me to the next level, and that's really true and honest mentorship. But I think many of us think of the mentees of Derek Bell as being students that he taught. As Randy Hertz mentioned, I've lived in Baltimore for 20 years teaching at the University of Maryland Law School, and much as I love NYU, it was not a mistake. It was a lovely decision. And the place where I have worshiped for the last 15 years is a church called Mount Calvary AME Church. The pastor of that church is a woman named Dr. Ann Leitner Fuller. And she often would tell a story about how she got her degree, her college degree. She was a secretary at Harvard, and the person that she worked for was a lovely man, by now you could probably guess it was Derek Bell, who told her that he was going to fire her if she did not apply to college. She had a young son. She wasn't college educated but wanted to be. And he took her to the admissions office at Boston College, which is where she wanted to attend, and had her pick up the application and write the application. And she attended Boston College, and you just heard me describe her as Reverend Dr. Ann Leitner Fuller. She later received her doctorate and has been listed as one of the 15 greatest women preachers in Ebony magazine. And when she would tell the story the first few years I was at the church, she never mentioned the name of the person. And then one year she just said that it was Derek Bell. And I share that story with you because I just believe we will never know how many people's lives Derek seeded into. And it's not just the people that we meet at Harvard and the people we meet at NYU, but it's just people all over this country. So this is number 3 on my NYU bucket list. Number 1 was being the speaker at the law school convocation 2 years ago. Dean Morrison invited me. Last year, I gave the university commencement address at Yankee Stadium. Come on, I mean, that was number 2. It's awesome, it's awesome. But number 3 is definitely giving the Derek Bell lecture. The other 2 opportunities I didn't pursue. I was pleased and surprised to get the call. But to be honest with you, I have been angling to give this Derek Bell lecture for years. I dropped hints. I've looked longingly at Janet from the audience. I think I straight out offered myself for the lecture to Lisa Boykin a few years ago. I wanted this, and here I am. And I have to say, I did not imagine myself as director counsel of the NAACP Legal Defense Fund when I imagined giving this lecture. And so this really adds a surreal dimension to what is already a dream come true. I have to say a special word of thanks to Janet Bell. Janet, as you know, is a force of nature, the woman to whom you absolutely cannot say no. And I want to celebrate Janet for keeping the spirit of this lecture alive. You know, Derek was an unusual man, an extraordinary lawyer and scholar and teacher. We all know this. But often when even extraordinary people leave us, no matter how much we love them or admire them, we lose sight of them. They move slowly to that other shore called memory. They lose their potency and power. But Derek is still with us because of his extraordinary spirit and because of the force, truth, imagination, and brilliance of his scholarship, because of the example he set of uncompromising conviction, because he was strong and still gentle, and a great intellect and a man of faith, because he was serious about justice but wore it lightly and made us smile. And Derek lives because of Janet Bell, who worked so hard to keep the spirit of Derek and the example of his leadership alive. This lecture plays a vital role in that project, not only because it keeps Derek's memory alive, but because it pays him forward by providing a platform for serious, honest, scholarly engagement on one of the most important, most potent, and most vexing issues in our country since its very beginning, the matter of race. And this lecture calls upon those of us who are activist scholars to remain true to the standard set by Derek, one of uncompromising truth-telling, meticulous research, clear vision. I hope that many of you will support the lecture with your contributions to keep it going. We need to support the intellectual development and scholarship of our study of race. It's a complicated subject. I say this all the time because we very often face a Supreme Court that treats race very simplistically. But those of us who engage with this issue know that it takes an understanding of history and psychology and social science and demography and economics and labor patterns and every discipline you can imagine. And every day you're learning, and you're learning how much you don't know. And so I hope you will support this extraordinary space where every year scholars can come and share with you their thinking and writing about race. So thank you, Janet. So I've been wanting to give this talk so long that I have about 3 Derek Bell lectures in me. And I played around with this, and I think I decided I'm just going to give all of them tonight. I'm going to weave them into one lecture, but it's actually a series of things I've been thinking about, one of which is the focus of a book that I was writing in the fall of 2002 when I was asked to take the helm of the Legal Defense Fund and had to put on hold. So I hope you won't see all the places where I've stitched this together, but I really do think they are of a piece because in my line of work, I'm compelled to try and understand something of where we are today on race. Last night, we had a huge gala celebration of the 75th anniversary of the NAACP Legal Defense Fund. 75 years, that's huge, huge. And I'm always proud to say there's not a room in America, including this one, that would look like it looks right now were it not for the work of the Legal Defense Fund, not one. And to lead an organization that has had that kind of profound effect on reshaping this country is an honor and a privilege, but also an enormous responsibility. The responsibility to try and understand where we've come from, where we're headed, and to try to push us in the direction of equality and justice. And so I've been doing a lot of thinking. Every time a police officer kills an unarmed African American, when I see the video of an officer killing a child or punching a woman in the face or choking an unarmed man to death, I spend time thinking about where we are as a country. After the Supreme Court's devastating decision in the Shelby County, Alabama voting rights case, a case we painstakingly litigated, or when the state of Texas imposed a new voter ID law that no longer allowed students to use their university ID to vote, and no longer allowed Native Americans to use their tribal ID to vote, but does allow for the use of a concealed gun carry permit as valid ID to vote. I spend time thinking about where we are, not just about how we would challenge the law. For example, in Texas, we did challenge the law and won, although the federal courts refused to suspend the voter ID law for last week's election. But I spend time thinking about where we are on race in America, how we got here, and how we can do the extraordinary work of pushing us to where we need to go. A lot of my thinking really begins from 1954 because, of course, that's the beginning of our country as a nation free from legal apartheid. Last year, we celebrated the 60th anniversary of Brown versus Board of Education, and so I spent even more time thinking about the road since Brown. Being a scholar and something of a legal historian, leading LDF for me, to be honest, is like being a kid in a candy shop because we have about 6,000 boxes of archives, several of hundred of which will be cleared and available for scholarly review next year when we launch our Thurgood Marshall Institute at LDF. So my fun time, and I don't know if our archivist is here. Donna Glockner, are you here? Donna Glockner right there. We have like really fun times rubbing our fingers over tasty things that she finds in the archives. And so I've been reviewing materials and looking for clues. that can help me understand where we are today in this country on the great issue of race, how we got here, and of course always seeking insight into where we might be headed and how I might lead. So spoiler alert, I haven't figured everything out. But I want to share with you tonight some of my thoughts, and I'd particularly like to talk about what I'm calling the predictive power of Brown. Because what I've discovered is that much of how we respond to issues of race today, much of our legal and political discourse, certainly much of even our physical landscape, has been shaped not by Brown, but by our reaction to Brown. And much of what we're seeing today was born and shaped in that crucible. So I want to talk tonight about Brown, about what we knew, and about what we feared, and about how this country has been shaped by our responses to what we knew and what we feared. So first, let's talk about what we knew. This is important because so much of what we understand about Brown, what we teach about Brown, what law students learn about Brown is the opinion itself. And I want to spend a little time talking about what is unsaid in the Brown opinion, but what was very much part of the LDS presentation to the court in that case. In the Brown opinion, as you all know, Chief Justice Earl Warren and the entire court together united behind a singular decision, and it was a monumental decision. The court powerfully rejected the notion of segregation as a custom of preference, but instead recognized segregation as an affront to Black citizenship, as a form of racial subordination. One of the most important aspects of the opinion is the court's recognition that education is one of the most important functions of state government and that prepares young people for citizenship. The story told by the court in the Brown opinion became the dominant narrative about segregation. And so it's worth remembering the court's conclusion about the harm of segregation. What the court said is, segregation of white and colored children in the public schools has a detrimental effect upon the colored children. Let me say that again. Segregation of white and colored children in the public schools has a detrimental effect upon the colored children. So let's sit with that for a moment because it's a powerful statement and yet it's so glaringly asymmetrical. There's a missing part to the equation. A narrative that was and is as important, and I would argue today with 20/20 hindsight, more important than the narrative about how segregation harmed Black children. The missing narrative is about the way in which segregation harmed and harms white children. There's no discussion of this harm in the Brown opinion, and yet it was part of the presentation of the case. In fact, the now famous appendix to our brief, signed by 30 social scientists, including the great Kenneth and Mamie Clark, the creator of the Dahl test, whose work was cited in footnote 11 in Brown, that appendix included the social scientists' powerful conclusions about how segregation harms white children. And I think today, 60 years later, we have to return to what they found. They warned, and I'm quoting now from their submission, children who learn the prejudices of our society are also being taught to gain personal status in an unrealistic and non-adaptive way. When comparing themselves to members of the minority group, they are not required to evaluate themselves in terms of actual personal ability and achievement. They often develop patterns of guilt feelings, rationalizations, and other mechanisms which they must use in an attempt to protect themselves from recognizing the essential injustice of their unrealistic fears and hatreds of minority groups. White children may experience, they said, confusion, conflict, moral cynicism, and disrespect for authority may arise in majority group children as a consequence of being taught the moral, religious, and democratic principles of the brotherhood of man and the importance of justice and fair play by the same persons and institutions who, in their support of racial segregation and related practices, seem to be acting in a prejudiced and discriminatory manner. And they warned some individuals may attempt to resolve this conflict by intensifying their hostility toward the minority group. Still others react by developing an unwholesome, rigid, and uncritical idealization of all authority figures, their parents, strong political and economic leaders. They despise the weak, while they obsequiously and unquestioningly conform to the demands of the strong, whom they also paradoxically subconsciously hate. From the earliest school years, children are not only aware of the status differences among different groups in the society, but begin to react to the patterns described above. This is powerful stuff. The court reviewing the Brown cases were well aware of this data, and yet none of it shows up in the opinion we all know as Brown versus Board of Education, which is premised on the harm of segregation solely to Black children. And it was ignored by most of the judges in the cases leading up to the Supreme Court. One judge did not ignore this data, Judge J. Wades Waring, who was a federal judge in South Carolina. And he was part of the 3-judge panel that heard Briggs versus Elliott, the South Carolina contribution to Brown. The South Carolina case in many ways had the most compelling facts of all the Brown cases because of the conditions of segregated schools there. And the plaintiffs in that case suffered perhaps the worst reprisals, death threats, and economic devastation as any of the Black parents in all of the Brown cases. In fact, Mr. and Mrs. Briggs lost their jobs and livelihood and were destitute and under threat of violence left South Carolina never to return. Judge Waring had an interesting story of exile from South Carolina after the Briggs case as well, but that's for another day. In any case, he was an 8th-generation Charlestonian, a Southern blue blood. But beginning in the late 1940s, he presided over a series of cases litigated by Thurgood Marshall. Marshall described his first trial before Waring, which was in a teacher pay case, as the only time that Marshall said he tried a case with his mouth hanging open most of the time, because Judge Waring was so fair in allowing Marshall to present his case. And it was unlike any experience Marshall had ever had in a Southern courtroom up to that point. But by the time he sat as part of the 3-judge panel hearing Briggs, Waring had decided several cases in Marshall's favor, including a case challenging the whites-only Democratic primary in South Carolina that mirrored Marshall's Supreme Court win challenging the Texas all-white primary, Smith versus Allwright in 1944. And in each of the cases that Marshall tried before Waring, Waring grew increasingly critical, and some would say strident, appropriately so, I would say, in his criticism of Southern white supremacy. And Briggs was no exception. Remember, the 3-judge court in Briggs upheld segregated schools in South Carolina, but Judge Waring dissented. And his dissent was regarded as a scathing denunciation of the society in which he was born and in which he flourished. And the reprisals that he faced were so strong that he retired from the bench and moved to New York and never returned to South Carolina until he was buried there. But I want to read to you a little bit of what Judge Waring said in his dissent, describing the evidence presented by the plaintiffs in the Briggs case about the effect of segregation. He said that the mere fact of segregation itself has a deleterious and warping effect on the minds of children. These witnesses testified as to their study and research and their actual tests with children of varying ages, and they showed that the humiliation and disgrace of being set aside and segregated as unfit to associate with others of different color had an evil and ineradicable effect upon the mental processes of the young, which would remain with them and deform their view on life until and throughout their maturity. And then he said, I think, the powerful line. This applies to white as well as Negro children. These witnesses testified from actual study and tests in various parts of the country, including in the Clarendon County, South Carolina School District under consideration. They showed beyond a doubt that the evils of segregation and color prejudice come from early training and from their testimony, as well as from common experience and knowledge and from our own reasoning. We must unavoidably come to the conclusion that racial prejudice is something that is acquired, and that acquiring is in early childhood. When do we get our first ideas of religion, nationality, and other basic ideologies? The vast number of individuals follow religious and political groups because of their childhood training, and it's difficult and nearly impossible to change and eradicate these early prejudices however strong may be the appeal to reason. There is absolutely no reasonable explanation, he said, for racial prejudice. It is all caused by unreasoning emotional reactions, and these are gained in early childhood. Let the little child's mind be poisoned by prejudice of this kind, and it is practically impossible to ever remove these impressions, however many years he may have of teaching by philosophers, religious leaders, or patriotic citizens. If segregation is wrong, then the place to stop it is in the first grade. And then he concluded in what became the most famous line of that opinion, segregation is per se inequality. It's worth reading the entire opinion. It's part of the materials for tonight's talk, and it's available on LDF's website. It's often been said that Chief Justice Earl Warren followed the template of Justice Waring's decision in Briggs, except for this one segment. He carefully adopted a more moderate tone and carefully walked around Judge Waring's discussion about the harms of segregation falling on white children. Justice Warren walked around the testimony of social scientists on this point in his footnote citing the work of Dr. Clark and others. So both the presentation of Brown and the dissent by a judge in perhaps the most compelling of the Brown cases talks about this phenomenon, but that narrative doesn't make it into the Brown decision. And this, I believe, is not inconsequential. In fact, I think it's monumental. The result is that the entire project of desegregation and of integration is described, understood, and internalized as a project to help Black people, to help little Black children with their self-esteem, to restore the dignity of Black people. And certainly that is part of it. But it was never understood as critical to saving white children, to preparing white children for citizenship in a pluralistic society, or as critical to the future of our united country. And I believe that 60 years later, we are still living with the fruits of this omission. We have never truly confronted how segregation harmed generations of white children and failed to prepare them for the pluralistic society in which we find ourselves. And as we watch these astonishing displays of indifference and violence and inhumanity in some of the videos that we have seen over the last year, I believe we must reckon with the reality that the record in Brown predicted with clarity not only what would happen to Black children, but what would happen to white children if we failed to reckon with segregation. And I believe it's time for us to re-engage the truth and the unexamined portions of the litigation we call Brown. So that's part of what we knew. What did we fear? Fear was palpable and toxic after Brown. And our response to that fear was truly extraordinary and must be examined as well. It shaped every institution in this country, from schools to courts. Many of you know about massive resistance, the effort by members of Congress and by leaders in southern states to resist Brown at all costs. You know about the closing of the Prince Edward County schools for 5 years just to prevent integration. And I really believe that those were the years in which we broke our covenant to provide quality public education for all of our children. Don't believe we ever returned from it. But I actually want to talk about a particular case that demonstrates the kind of fear that existed in the year after Brown. And I think that shows how pervasive this fear was all the way up to the United States Supreme Court, which after all had just decided Brown. So it's important to remember that in 1955, the year after Brown, it wasn't clear how fast these changes might come. In fact, as you know, we had Brown 1 and then we had Brown 2. And Brown 1 is the opinion that with the soaring language full of promise, sadly with the omission I've just described, and Brown 2 was a little pump of the brakes. That was the decision in which the court hedged bets a little bit and said that desegregation would proceed with all deliberate speed, and suggested that local courts and jurisdictions would be given the ability to determine how to begin to proceed in a graduated way with desegregation. And many of us know what the outcome of that was. It gave time for Southern jurisdictions to marshal their strength, to develop massive resistance, to create private white academies, and to essentially create shadow school systems for white children in many jurisdictions. But it wasn't clear in 1955 what Brown would really mean. We look back on it now and we see how it began to unravel legal apartheid. And so that year, 1955, the subject of race and Brown's reach was the text and subtext of a lot of cases that were making their way up to the Supreme Court. And in fact, in 1955, this fear about what Brown might mean became the focus of that year's Supreme Court confirmation hearing of Justice John Marshall Harlan II. In fact, in the book that I'm writing, that I referenced earlier, my thesis is that the modern Supreme Court confirmation hearing was in fact born of Brown. Prior to Brown, confirmation hearings were a fairly routine affair. There were one or two notable exceptions. Judge John Parker in 1934 had to answer questions about racist remarks he'd made during his run for governor of North Carolina, and he ultimately withdrew, later to sit on that Briggs case that upheld segregation. Justice Brandeis faced an ugly and drawn-out set of inquiries about his law practice and potential conflicts, and certainly the hum of anti-Semitism vibrated below the surface but was never explicitly expressed. But these were aberrations. Supreme Court confirmations were routine affairs. Normally the candidate, the nominee, didn't even appear before the Senate Judiciary Committee. It was kind of all done on paper. What we've come to know as the modern Supreme Court confirmation hearing, when the nominee comes before the committee and answers questions over days about a range of their views on controversial topics, that was born out of racial anxiety about Brown. Now, Justice Harlan II was no radical. To be honest, he was no real profile in courage. He paled in comparison to the conviction and courage of his grandfather, the first John Marshall Harlan, who wrote the famous Dissent in Plessy versus Ferguson in 1896. He was what they call, which I call damning by faint praise, an able lawyer. But Brown had been decided the year before, and there was some anxiety and some might say hysteria in the air. And on the Senate Judiciary Committee, led by Senator Harley Kilgore of West Virginia, the post-Brown anxiety centered itself on a case making its way up to the United States Supreme Court. Senators, and we later learned some Supreme Court justices, feared that this case would get to the court too soon and force the court to take on a broad range of segregation issues in American life, parks and swimming pools and hotels, and in the subject of this case, cemeteries. The case was Rice versus Sioux City Memorial Park, and it involved the burial of a man named John Rice. John Rice was killed in Korea in 1951, and actually was killed in 1950, and his body was flown home for his funeral. Rice was killed in action. He received the Purple Heart, Bronze Star, and many other awards for his bravery. And on the day of his burial, his wife, Evelyn Rice, several weeks before had signed a contract with Sioux City Memorial Park for a plot in the cemetery where she would bury her husband. And they all assembled, she and her 3 children, Pamela and Tim and Jean, and members of the extended family. And they assembled to bury John Rice. And after they had the ceremony at the burial site, but before they lowered him into the ground, she returned home with the children. And about an hour later, there was a knock at the door, and it was the owners of the cemetery. And they came to tell her that now that they had seen the people who came to mourn John Rice, they realized that they could not bury him there because, in fact, it was apparent that he was Native American. She, Evelyn Rice, was white. And of course, her children were there, and I've met and talked with the family, and even though they were very young, the children, they remember this very vividly, the fear and the confusion and the embarrassment when they told her that they would not be able to put her husband in the ground. But because he was a soldier and there were military men at the funeral, something different happened. They were actually quite disturbed and angry that the cemetery refused to bury John Rice, and they called Washington, D.C. to talk about this terrible thing that had happened in Sioux City. And the word got to the president, Harry Truman, who was outraged. And he sent a cable to Mrs. Rice the following day telling her that her husband could be buried in Arlington National Cemetery. And ultimately, he was buried there. But before that happened, the members of the Sioux City Memorial Park came again to visit with Mrs. Rice and told her if she would just sign an affidavit saying that he was white. They didn't care that he wasn't white. If she would just sign it, they would be able to bury him. And Mrs. Rice was not a civil rights pioneer. She was not an activist. She was a devastated widow. But she refused to sign. She said she could not understand. She had no shame about him being Native American, and she couldn't understand why she would deny that he was Native American. In fact, she had grown up near the same reservation as he, she and her sister. She and her sister married two brothers, John and his brother. She'd known him since she was a young girl, and he was truly the love of her life. So she refused to sign, and her brother-in-law, John's brother, convinced her to go see a lawyer, and although she was very reluctant and actually quite shy, she went and they filed the case. So the case made its way up to the Iowa Supreme Court. The Iowa Supreme Court did not rule in favor of Evelyn Rice, and now the case was headed to the United States Supreme Court. And in fact, when the confirmation hearing of John Marshall Harlan was happening, the case had already, in fact, gotten to the United States Supreme Court. And the Supreme Court, on November 15th, 1954, this is the same year as Brown, essentially upheld the decision of the Iowa Supreme Court by splitting 4-4. This is the same year as Brown, and they uphold the decision of the Iowa Supreme Court that Mrs. Rice did not have the contractual right to bury her husband in that cemetery. So this was in the air, and many of the senators were very distressed about the possibility that this case would go to the Supreme Court again somehow, and wanted to know, where do you stand, John Marshall Harlan, on this set of issues? In fact, Senator Hart on the committee, Judiciary Committee, described it this way. He said, "One of the country's greatest needs today is restoration of the Supreme Court to its historic stature. Its prestige has fallen to a low ebb. Too often in the past 20 years, the court has become a political body. One example is the segregation decision, in which the court usurped the functions of the Congress. Every nomination to the Supreme Court should therefore be considered in light of this need." And I actually believe every nomination to the Supreme Court has been considered since then, in light of that concern. So I came to learn about the Rice case because I was writing about Supreme Court confirmation hearings, and so many of the questions of Justice Marshall were about the Rice case. Now, I should tell you that, you might wonder, since I said he was just an able lawyer and not a profile in courage, why were they asking him all these questions about the Rice case? Well, in the Rice case, a brief had been submitted suggesting that the actions of the Sioux City Memorial Park, in addition to violating the 14th Amendment, also violated the recently ratified UN Charter. And Justice Harlan had nominally made himself a part of an organization that was focused on promoting the UN Charter. When I say nominally, as he testified, he just signed a sheet that somebody put in front of his face. He'd never attended any meetings. He didn't mean to. But this was enough to suggest to them that he might be one of those people who was interested in, one world order. And so that was the focus of their questioning. Meanwhile, inside the Supreme Court, there was an effort not to deal with this issue. So the court had split 4-4. But they understood that the case was going to come back to them because there was an effort to seek a rehearing. And behind the scenes, and I'm still learning more about this, Justice Frankfurter was deeply concerned about the court getting what he would call ahead of itself. He really believed that there needed to be moderation post-Brown, and he did not want the court to step into this next phase of dealing with the issue of segregation. And so many efforts were made to try and find procedural grounds on which to not hear the Rice case again. Nevertheless, the case made its way there. John Marshall Harlan was confirmed in March of 1955. There was a petition for rehearing of the Rice versus Sioux City Memorial Park case. And the Supreme Court did something kind of interesting. In May 1955, it's almost a year to the day, May 9th, 1955, almost a year to the day after Brown won. And the court does this. They grant the petition for rehearing in Rice, and then they vacate their earlier decision on the grounds that cert had been improvidently granted the first time. And the basis of cert having been improvidently granted was that there was something happening in Iowa, and it was a furious effort to pass a state statute that would make the case go away. In other words, a state statute that would end segregation in cemeteries, which they did. They did pass that statute. That statute had already been passed the first time the Supreme Court heard the case, however, and they heard the case and split 4-4, but now this time around, the court said, you know, we didn't really notice the first time that we shouldn't have heard it, but now we can really see that cert was improvidently granted, and so they were able to remove themselves from this very volatile situation. There was a dissent from Chief Justice Warren, Justice Black, and Justice Douglas. But this case shows you how fearful the country was, and even the justices were, about what integration might mean and about how quickly it might move. This fear of integration also changed the landscape of our country. As you know, it set off a kind of great migration of sorts, an ignoble one, I might add, but still an exodus of whites from cities across the country. Unlike African Americans who fled the South seeking opportunity, jobs, and fleeing the terror of lynching and violent white supremacy, the white migration to the suburbs involved opportunity, yes, the creation of the white suburbs supported by massive government investments coincided with the end of legal segregation, but also involved a flight from the terror of the imagination, a terror conjured from ghost stories about integration and miscegenation and the loss of white power and prestige. White flight changed northern cities as powerfully as the Great Migration did of blacks from the South. In fact, for a brief period of 20 years or so, both migrations were happening at the same time. Blacks were still coming up from the South to seek opportunity in northern cities in the 60s and early 70s, as whites were leaving cities for the suburbs to avoid integration. The fear of integration began what became the abandonment of the public school system in this country, first through massive resistance, as I described earlier, and then the busing wars of northern cities in the 70s, and ultimately as a matter of public policy. Truly integrated schooling happened for a brief 15-year period that coincided with the period after the passage of the Civil Rights Act of 1964 and ended soon after the Supreme Court's decision in Milliken versus Bradley in 1974, when the court decided that city integration plans could not extend into the suburbs. I, and perhaps many of you, were bused to integrated schools during that brief period, and perhaps someday our story will be fully, or should be fully told. The contemporary landscape of America, hyper-segregated, with development and white flight reaching further and further out as blacks moved into the suburbs, moments of intense gentrification pulling whites back into pockets of major cities, with racially segregated, deeply distressed, poor black communities, public schools that are often almost upwards of 90% black or 90% white in cities and suburbs. This landscape is the result not of Brown itself, but of the irrational and destructive fear of what Brown would mean. So what shall we say to these things? I believe that we must return to the project of understanding integration, a word that is old-fashioned and perhaps sounds irrelevant these days. But if we're honest with ourselves, Segregation is killing the fabric of this country. We do not know each other. We stand apart from each other. Our experiences are often too different. We don't understand the experiences of one another. And the integration I speak of is urgently needed because if we're ever to prepare our children for the exercise of responsible citizenship in a country that's increasingly diverse, it is urgent and essential that we deal with this. Because economic integration follows racial integration, and we cannot continue as a democracy with the vast chasms of income and wealth inequality in our country. The project is urgently needed, or else we will continue on this endless loop, this recurring reel from Detroit to Watts in 1966 and 1968 to Los Angeles in 1994 and Baltimore in 2015, from the killing of 10-year-old Clifford Glover in this city by the NYPD in 1972 to the killing of 12-year-old Tamir Rice by Cleveland police in 2014. And after all, it's not only the killing of Tamir Rice, it's the officer who shackles Rice's teenage sister when she cries and screams as she sees her brother dying. It's when he says to the mother, "I'll arrest you too if you don't stop screaming." So what should be the elements of this project? First and foremost, we must return to the issue we grappled with before Brown, I believe, housing segregation. In the years before Brown, housing segregation was as much a preoccupation of LDF as education became in the years after Brown. It was in Hurd versus Hodge, the case brought by Charles Hamilton Houston successfully challenging racially restrictive covenants in Washington, D.C., that we filed the first Hurd brief, a complex and detailed 80-page brief that included economic and sociological data about the effect of racially restrictive covenants and housing deeds on the health and economic conditions of blacks living in the cities, on the strength of black families, on attitudes about race and racial prejudice, and on what was described in the brief as the international, national, and moral implications of this form of housing segregation. That Hurd brief became the template for the brief of the sociologists in Brown and for hundreds of amicus briefs that we now file as a matter of course in the United States Supreme Court. Hurd, of course, led directly to Shelley versus Kramer, which struck down judicial enforcement of racially restrictive covenants in state courts. And when Shelley was decided in 1948, it was a great win for LDF. Marshall received telegrams from around the country, and all signs pointed to a continued focus on housing segregation. But in 1950, Marshall and the LDF team won a monumental case in the Supreme Court, Sweat versus Painter, in which the Supreme Court rejected Texas's efforts to hastily establish a separate law school for black students, Texas School for Negroes, they called it. And instead, the court determined that a separate law school for black students and the law school at the University of Texas could not ever be equal, that they were per se unequal. And the LDF lawyers now saw that winning a challenge to segregated public school education in K through 12 was in sight. In 1951, Barbara Johns, in the 11th grade, led her fellow students in a walkout from her segregated high school in Prince Edward County, Virginia. And that courageous act of civil disobedience by a 16-year-old girl and her peers pushed attorneys Oliver Hill, Spotswood Robinson, and LDF to file Davis versus County School Board of Prince Edward County, the Virginia case that became part of Brown, and the rest, as they say, is history. It took nearly 30 years and the assassination of Martin Luther King for a concerted civil rights focus to return to the attention to the issue of housing segregation. The Fair Housing Act was passed in 1968, just 6 days after the assassination of Martin Luther King, while cities all over the country burned in the wake of that terrible, terrible assassination. Nevertheless, we remain deeply segregated, and I regard the segregation issue as one that is not only about law, but also about investments and infrastructure, transportation policy, and so many other areas that we traditionally ignore or give little attention to in the civil rights space. But the creation of the interstate highway system was a civil rights issue. We didn't know it at the time, but it made the creation of the white suburbs possible. It was an investment in the creation of the white and segregated middle class. And that investment, while a good thing in the abstract, that investment made at the time that the FHA still supported and encouraged the development of all-white enclaves like Levittown, had as much to do with thwarting the promise of Brown as the foot-dragging of timid federal judges. So we need a broader lens for understanding civil rights challenges like segregation. We also need a candid and clear evaluation of how this country has benefited from even our tentative steps towards equality. The wealth that the US has amassed, its leadership in the world, especially during the Cold War, as Derek Bell wrote about in his interest convergence theory, the leadership of business people and political leaders in the world has been enhanced by the story of America as a place of equality and promise. The very terms in which we describe ourselves as a nation were created by the civil rights movement and by civil rights litigation. And we've marketed those words and that image of our nation to leverage our economic, political, and military might all over the world and at great profit to many. Civil rights lawyering and activism created a 20th and 21st century narrative about America that has quantifiable value. The case for equality should be made on the basis of what it will do and has done for our country, not just as a gift to racial minorities, or free stuff, as they call it. Derek began this work with his interest convergence theory, and I'd like to see scholars do even more detailed work quantifying the equality dividend for our nation. This is what we gave America, and we get very little credit for it. And if we truly do care about our children, we must return to the conclusions reached by the social scientists in Brown. Even if we don't agree with all of the methodology, we must certainly admit that not just Black people, but white people, the soul of our country, the health of our democracy, the integrity of every institution, all of these things have been harmed by segregation and, as they said in the brief, related practices. As we deal with the ongoing and stubborn issue of racial discrimination, as we grapple with police killings of unarmed African men, women, and children, and voter suppression, as we look at the vast economic equality gap between Blacks and whites, as we wonder why the racism that we see today seems to be so stubbornly and disappointingly similar to the racism we encountered and thought we defeated years ago, I hope that we will re-examine Brown not only as a beginning of our democracy, but also as a crossroads, as a moment when we failed to take the necessary step of confronting the full measure of segregation's corrosive effect on our society, and when we allowed fear to overcome hope and possibility, and the danger of doing that once again. My work and our work at the Legal Defense Fund is focused on completing the unfinished work of Hurd and Shelley and Brown, and on using that broader lens I talked about to demand investments in infrastructure and supports that accompany our legal wins, to win cases, but also to follow the money, and to take care that we attend to the narrative that we shape in our cases, and that narrative that gets reshaped or ignored by judges and scholars and the media. I think often about the dignity and heroism of John and Evelyn Rice and their 3 children, who are some of the most extraordinary people I've ever met, a dignity that was challenged by fear, the fear of what integration would mean, the fear of true equality, the fear of a true democracy. But having met that extraordinary family and having heard them and talked with them, I still believe they won. But I also believe that their courage and the courage of the Briggs family and countless others who created the sacrifice for us of participating in these extraordinary cases and taking these extraordinary actions, standing against fear, requires us to be brave enough to return to that which we know and knew, and this time to win. Thank you.
That was fantastic. In keeping with tradition, we will take some time now for questions from the audience. We have microphones in each aisle. Please identify yourself and feel free to ask our lecturer.
Thank you very much, Ms. Ifil. So I'm Nigerian, and many of the stories about racism in Nigeria and in America are pretty, well, not new, but it's very interesting to see how they play out in reality. And I guess there's been sort of a move from attacking people's blackness to attacking something that could be related to their blackness. So we're not saying, you know, you're subhuman because you're black, but we're saying, you know, you're subhuman because you're violent or you're incompetent. And I'll just give a very short example. I lived in Cairo for about 2 years, and I remember just after I moved to Cairo, I was walking down the street one day, and this woman sort of slaps me in the face, like just walks on. And you know, many of the Americans I met were really shocked, like, why would she do that? But my Egyptian professor was, oh yeah, you know, like Egyptians they're racist, so that's why, it was because you were black. So it was a very direct attack on my blackness. But that wouldn't happen here in America. Yesterday I sat in a class and we discussed Richard Sanders' paper on affirmative action. And it's a different kind of attack. And I remember listening to a student in that class ask, and I paraphrase, you know, so why do the black students go to the elite schools? Like, don't they realize that they're not going to, you know, make it there? And I remember thinking, okay, that's sort of worse than somebody sort of slapping you in the face and saying it's because you're black. Because they're not saying the blackness is the problem. And so you can't immediately call it being racist. And so my question is, how would you react to that, you know, to the Sanders paper and to the Fisher case that the Supreme Court now has to hear? It's a different kind of racism that you're having to deal with than in Brown.
Thank you very much. And I'm sorry for both of those experiences that you had, which are both awful. So we just filed a brief on Monday in the Fisher case, and you can go on our website and read our amicus brief, but your point is well taken. One of the difficulties, of course, of dealing with race is that it changes so much in how it manifests itself and sometimes loops back on itself. And of course, we do have a whole lexicon in our country now that manages to talk about race without ever talking about race. And we were just talking about this at a conference a few years ago. I mean, we can use words like inner city or urban, or tax increases, or whatever are the words that you can use to infuse race into a conversation without ever really dealing with the issue of race. And in some ways it makes it harder because now it's buried 2 levels down, and you have to do the 2 levels of argument at the top, which are actually irrelevant to even get to the bottom argument, which is really the argument. And you have to deal with the conviction of many that they're not talking about race, and the genuine belief that they're not talking about race. And this is a little bit what I was talking about when I was talking about making sure that we're attentive to the narrative, which I think sometimes we haven't been. We have not been sufficiently careful about protecting our language and our story. And I think that's what I was also trying to say in this paper, that story in Brown, I mean, we won Brown, so we were happy we won, and when you win, you don't go back and question the judge about, how he said or how she said what she said. You're so happy you won. But, it matters that Brown talks about, this idea of harm of segregation just in the realm of black people, because part of what it does is it constantly talks about black people as having the problem, either the problem of victimization or the problem of some kind of pathology, and it never examines the problem of white people. And frankly, in the history of this country, the problem of race is largely a problem of white people. So it situates the problem in a way that we have been building from ever since. So even the premise that we're starting from is flawed. And we just keep kind of responding to that set of arguments. And so it's very, very difficult. But I do think that we have to be attentive to unpacking the layers that you're talking about. And it takes patience and it takes time, but it has to be done. And of course, the affirmative action debate is one of the places where, race hides out so effectively. And I think it's really important to be forthright about it. What I should also say is that the Supreme Court has, by their decisions, also pushed the race conversation into a corner. And, we're lawyers, we're litigating, we have to accept, in some ways, the terms that the Supreme Court has set. And so we start, having a conversation in a way that's not fully robust. So there's a lot of this part about the language and about the use of language that we have to be much more attentive to and careful about, and consider that part of the win that we're trying to get as well, that there is a legal win and there's also a narrative win.
Yep. Hi, my name is Chuck Warren, and I have a question about Earl Warren, no relation, but he went to great lengths to make it a 9-0 decision
Right.
because he thought that was extremely important. Do you think he could have gotten to that 9-0 if he had tried to bring in the issue of the impact on whites, which I think it's a very important point you're making on that, and I agree with it. But do you think he could have gotten to that? And if it had been a much more divided decision, would that have had the same kind of impact?
So let me say, I can answer that question very easily. No, he couldn't have gotten to the to the 9, I think. And I think this was a pragmatic decision that he made, and a completely understandable one. So it's actually not as much a critique of him as it is an understanding of the kinds of decisions that get made and the consequences of those decisions. I also have often complimented Justice Warren for his understanding of the importance of the unanimous decision. And that's actually one of the things I've criticized our current Supreme Court about. Because I do think that there have been moments in which the Supreme Court, even in decisions I didn't agree with, understood the importance of a unanimous decision in a particularly controversial political case. They did it with the Nixon-Watergate tapes. They did it with Jones versus Clinton, which was, I think, 8-0. And I have, said it's one of the worst things about Bush versus Gore was, the fact that you had in this very important political case this divided court. So, Cooper versus Aaron was a unanimous decision. I think that's really important. There's no question that Earl Warren believed that he could not get a decision with this other piece. It's also worth remembering that Judge Wades Waring, who I spoke about earlier, who wrote that Briggs decision, Warren wanted to use it as a template, but everyone understood that you needed to distance yourself from Wades Waring, who was seen now as a bomb thrower, in terms of the kind of rhetoric that he used in his opinion. So Warren wanted to get to the core of it without all the stuff that would be most incendiary, and I think that's the Brown decision that we see, which, by the way, was still monumental and quite incendiary in 1954.
Thank you so much for your lecture. My name is Anurag Gupta. I'm a graduate of this law school and also a former student of Professor Bell's. And I work in the field of racial justice, and something that I've been kind of contemplating for a while, and your lecture really brought forth some of these issues, was, of course, Judge Waring's decision that wasn't incorporated in the Brown decision, but also thinking about the narrative aspect of race and what race actually means and what whiteness is, as opposed to non-whiteness, Native American, Latino, Black, whomever. And in terms of the elements of integration that you talked about towards the end of your lecture, in terms of solutions, you said that we must start at housing, and then, but I mean, for me, like, I always wonder, how can we litigate or actually force people to have intergroup contact, interracial contact, when that fear, that racial anxiety is so prevalent and pervasive in the mind of everyone, and then it's pretty much perpetuated and without any regulation by our media. So is there any role of, innovative legal thinkers as well as litigators in thinking about how we can correct the story of the falsity of biological race and all sorts of negative stereotypes that are associated with that.
Well, I think I want to answer the part of the question about housing and how we deal with, this fear that people have of one another. Because, I've been doing a series of lectures with Richard Rothstein, who is a fellow at the Economic Policy Institute, about housing segregation. And I would say, we do almost like a dog and pony show, and I would say the core of it is to try to help people understand that the landscape of America, the segregated landscape of America, has very little to do, has something to do with, but on scale, very little to do with the individual prejudices of individual people, like white people not wanting to live next to black people. But that in fact, the landscape of this country in its segregated form is largely the result of government policies and massive investments. And this is the part I was talking about when I say we very often leave this off. So the landscape that we see today, including the creation of the white suburbs that I talked about, the interstate highway, think about all the things that created the white middle class. These were massive investment, I might say entitlement, but investment programs, the GI Bill, the interstate highway system, the credits, the development credits and the tax breaks that were given to these all-white enclaves. The fact that the FHA from the 1930s, when it started providing mortgage insurance, until the 1960s required racially restrictive covenants. They required segregation. Public housing was required to be built on a segregated basis by the federal government. It was created by, you just can't explain it any other way. It's not just these individual interactions. And I think part of our problem is now, I want to talk about racism and not race, which is that we think about racism as a personal, emotional thing, as opposed to as a set of, expressed in a set of structural policies that affect the landscape. And so that's why I've been talking about the issue of investments. When we decide that we want to invest in something, we do it and we find the money to do it. We've invested in young people, we've invested in mental health, and we've invested in, jobs in a massive way over the last 30 years. And you know what that investment is called? Mass incarceration. Right. It's money that we decided to put in to dealing with young people and dealing with our job issues and dealing with people with mental illness. And that's how we decided to do it. We could have done it another way, but that's what we did. But we should remember that that's an investment. We shouldn't just talk about mass incarceration as though it's just about a set of civil rights policies and so forth. And that's, I guess, what I'm trying to suggest, that even as we unpack and talk about the narrative, we should be mindful of the fact that race exists, or racism or racial neglect exists in the investments and the infrastructure and so forth that we make. And the reason it's so important is because that's what your kids and your grandkids are going to live with, right? You're driving on the same streets that, that your grandkids would be on. And so when we allow these investments and this infrastructure to just go forward, we're really solidifying for generations to come, right, what the landscape is going to look like. So I just would answer your question by saying that I think we need to focus more on that, focus more on the way in which it's expressed through investments and policies. And when we decide that we want to give investments to have an integrated society, I'm pretty much betting we can do that too.
Thank you.
Good evening. I actually, like your pastor, my name is Yola Nicholson, and I'm one of those people that Dr. Bell touched just for a moment. I was a third year at Columbia, and I think it was in, 1989, when I think he was just coming back, or coming here from Harvard, and he gave a lecture, and if I remember the story correctly, and then I'll tell you my question because it's related to the story, and I think it's probably in one of his books, an anecdote of, a big meteor, or whatever the equivalent was at the time that he would have described it, hitting the earth, and we're all being put on spaceships to get off this land, and, all the suburbs and all the people got there, and when the people from the inner city, which are the black people, showed up, they go, oops, sorry, there's no more room on the ship. It's not, we didn't really mean to leave you out, but, so it's not really racism, but it was just that the ship is already filled. And I say that story to say that you've touched on, racism and investment. I wanted your thoughts on the following. As we know, after World War II, there was a huge investment made, as you pointed out, in housing to create a white middle class. And the black middle class in the alternative had to really build this up on their own, work as civil servants and save, and nobody gave them mortgage insurance. And then we ended up having an economic and housing crisis, and they got blamed for it, and they got blamed for being deadbeats and for taking out too many subprime loans. And there's a celebrated policy from the federal government to divest all these, poor black people who should not really have been able to own their homes because they just don't know how to pay a mortgage. And in the process, they're divesting our communities of, I think it's something like billions of dollars, 3 times the divestment. And my question is, from the Legal Defense Fund's perspective, how do you think we should approach this? Because it's a racism and a divestment versus a lack of investment, but it's still institutional racism. And everyone has come on board. The courts have come on board. The financial industry has come on board. The public has come on board to say, it's okay that these black people should really lose their homes and turn into renters. That's my question.
Well, it's a heavy question. So let me just say 2 quick things without taking too much time. The first thing is that this is the perfect example of where there was a narrative moment that we did, and we allowed it to be taken over, right? So I just said urban inner city subprime is one of them, right? You don't have to say race, but everybody knows what you mean. Where this housing crisis, which was a direct product of the financial crisis and which had lots of complicated reasons for its creation, was described in ways that, just as you explained, as though this was really more about black people not being responsible, about affirmative action in housing loans and the result of it. And I would have to say that was allowed to happen. Here was a moment when the entire country was questioning the economic policies that underlay, our society. And it was an opportunity to really come together with many others who were questioning as well, and to really create a united, multiracial coalition of people who had real questions and wanted real answers. I mean, the housing crisis was devastating for the African-American middle class. 25%, a full quarter of the African-American middle class found itself in foreclosures or in imminent foreclosure during that period. It was a huge wealth drain from the African-American community that has not recovered. And so there was a moment, but sadly, that moment turned into one in which the rhetoric is precisely as you described. And that's part of why I suggest today that as we look at issues around fair housing, we worked a lot on the Fair Housing Act case that the Supreme Court decided last year, and we look at some of the litigation one does, you have to be looking at it in concert with the issue of investments and infrastructure. And those are policy issues, because that's where that big money is that's gonna make decisions that are gonna lead us in one direction. And so when I talk about broadening the lens, that's what I'm talking about, is making sure that the litigation is accompanied by attention to the narrative and the story that you're telling, but also attention to the policy dimension and the investment and infrastructure dimension that goes along with the litigation.
Thank you.
Thanks. Thank you for the lecture. It's fascinating. I was wondering if you could just give any thoughts you have on the interaction between the Brown decision's omission of the harms done to white people by segregation and the cases that essentially state that affirmative action is only acceptable if it benefits white people, or doesn't only benefit black people, or whatever the racial minority at issue is.
Well, I'm not sure I quite understand that thesis.
I'm talking about basically the justification of the affirmative action not being race discrimination is that it benefits everyone, and that's a requirement for affirmative action to be accepted. And so I'm wondering if maybe there's some in there to kind of get the benefits of desegregation, you know, stated more clearly by the Supreme Court, or and you know,
Yeah.
just any thoughts you have on that topic?
Well, I think there's certainly, and many education leaders, you know, would and do support the idea that, you know, and that I think should be advanced, that affirmative action is not simply about giving stuff to black people.
Right.
And that's part of why I so dislike the word racial preferences. If we're to accept the Supreme Court's doctrine in the Grutter case and Fisher 1, that educational institutions can pursue diversity in building their classes, they're pursuing it not to benefit individual particular students, but to benefit the entire student body, to benefit the atmosphere at the institution, and particularly to benefit the leadership possibilities of those students. And in that sense, I think it does connect with some of the stuff that was discussed in Brown, right? The ability to, obviously we're talking, you know, Brown was talking about grade school and this is talking about the university system, but the idea that part of your development of yourself as a citizen and as a leader requires that you have the ability to engage with people in your society in ways that are rational. And I think Brown was cueing to us that, you know, by kicking the can down the road, we will be kind of fostering this continued irrationality that happens with young school children. In the affirmative action context, I think what many of the educators are telling us, and I talk about this a lot in the context particularly of state schools, where I think state schools really have a very clear mission to create the leaders for their state. I mean, I know this because I made that really great decision to go teach at University of Maryland Law School, where we know that we are literally educating the next leaders of the state of Maryland, right? If we look at the legislators, and we did a little study on this, if, you know, upwards of 90% of all the appellate judges in Alabama went through the University of Alabama system, 78% of the legislators in Florida graduated from the University of Florida, same would be true in Maryland and so forth. We're literally educating the leaders of the state. And it makes sense for a university to be saying, I want the leaders of this state to not be bedeviled by what is described, right, in the social scientist brief. I want them to be able to grapple with and be leaders of this pluralistic society and to be able to engage with people across race and background. And thus, my mission to create these leaders is aided by affirmative action. And in fact, creating a diverse class is essential to our leadership function. And I think that's what educators are trying to say in those cases. And I think actually if we understood what Brown, what the litigation in Brown was suggesting is the harm of segregation across race, black and white, then it would be easier to understand the argument that educators are making about how you prepare leaders or how you prepare citizens to engage in a pluralistic society.
Is the conservative wing of the court then, you think, in their skepticism?
I'm sorry, is what?
Is the conservative wing of the Supreme Court, is there kind of skepticism about the value of affirmative action? Do you think it's related
Skepticism is such a nice way to put it. Oh my. Yes.
Yeah. So you think it's related to this to a total rejection of of that benefit? Are they kind of one and the same?
Look, I would not call it skepticism. It's very clear that there are 4 justices on the court who do not believe in affirmative action at all. But I think there are also, 4 justices on the court who don't believe in the issue of race, as a real issue. This goes back to what I talked about at the very beginning. So much of what they say treats the issue of race and its connection to law as something very simple. You remember in the parents involved case in 2006 when Justice Roberts said, the only way to stop racial discrimination is to stop discriminating based on race. Oh, there you go. So it's all very simple. When we argued the Shelby case, Justice Scalia said, I understand what the Voting Rights Act is about. It's a racial entitlement, and nobody wants to vote against anything called the Voting Rights Act. That must be it. We have a whole record in the case, but I don't want to focus on the record. I think I know what's going on. So one of the things I think is really important, and that actually differs from where we were in the Brown case, is that we have to talk about the willingness of federal judges and certainly justices on the Supreme Court to allow us in the crucible of litigation to educate them about what they do not know. And particularly as we have a Supreme Court that is increasingly homogenous, notwithstanding the fact that we have 3 women and a Latino on the Supreme Court, which is lovely, you know, it is like 2 law schools, you know, all former prosecutor. I mean, it's a pretty narrow slice of even the legal profession, let alone of life. So I think that one of the struggles we have as litigators in this space is the increasing unwillingness of the court to have the humility to recognize what they don't know and to allow us to do our job as litigators to build a record. Litigation has an educative function. And if a judge is willing to be open and allow him or herself to be educated, we can show you how race works in the lives of the people that we represent. But you have to be open enough to recognize that you don't know everything and that it's not going to be subject to a simple bromide or formula that makes you feel better about how you can solve those problems. So that's just an ongoing challenge we face as civil rights lawyers.
Thank you.
This has been an important evening. This is a deep and profound lecture. I've taught Brown against Board of Education about 20 times. The 21st time I'm going to teach it differently because of what I learned tonight. Thank you. I think it is in the best tradition of what Derek continues to teach us that Sherilyn has reminded us tonight that as we confront deep and troubling and deeply upsetting problems of race today, we cannot forget what we know already. And he demands that we not forget that and that we act on it. And I think Sherilyn's call tonight is precisely the same. Thank you for that. Thank you to all of you for being here. I hope you'll join us for a reception in Greenberg Lounge after this.